find out in a moment if it's long enough. Okay. Good afternoon, everyone. I'm David Mortman. I'm your privacy wonk for the afternoon. I hope you all had a safe trip in with all the rain and all that good stuff. And so let me just give you a little... I keep changing my name here. So basically what we're going to talk today about is something about some privacy regulations, and then we'll talk about what this means to us. And what can we do about things to either improve things, make things worse, or whatever else you have questions about. Privacy, not privacy, I don't care. I'll talk about anything. Okay, so who here has heard of CA 1386? Anyone? Okay, we have a couple of people here. So basically, about 4 or 5 years ago, California passed a law that said that if companies have some sort of breach of your personal information, they have to let you know. So probably at this point, everyone in this room has gotten at least one, if not dozens of letters from various companies saying, oops, we lost a hard drive, we lost a laptop, we had hackers, you name it, they screwed up, and your personal information has been put somewhere on the internet in people's houses. My personal favorite was actually happened to a friend of mine. She started getting faxes at her house of people's medical records because someone transposed the last 2 digits in a fax number. So she started getting people's personal medical records from all over the place because it was from a major healthcare provider who handles several states. So she knows people's HIV status now, what kinds of cancer they have, all sorts of yummy things. And it took her several weeks of calling to get them to actually fix the problem. And so fortunately, she's a very nice person and has a paper shredder and just stuffed all that stuff down the shredder. Unfortunately, she couldn't actually turn her fax machine off because she needed it for her business. So it was an exciting time and involved a lot of wasted paper, not to mention all sorts of exciting information that she now knows about maybe someone in this room. So California started doing this, and as of the end of last year, some 39 states have passed similar laws, which has sort of shown us you have seen probably an exponential increase in the number of these letters, emails, advertisements on the sides of buses about this problem. And in fact, recently, Minnesota actually went even further, which was they made your credit card numbers fall into this information. They codified parts of the PCI legislation, which is, for those people who aren't familiar with it, makes all the vendors, anyone who deals with your credit card number in any way, shape, or form, go through all sorts of extra hoops to protect that data, which actually ends up putting a lot of effort, a lot of weight, especially on smaller providers of things. So if you go to your little mom and pop store down the street and they swipe your credit card number, they have all sorts of things they need to follow, like storing credit card receipts for months on end, just in case something happens. Of course, this also means that as a result, if someone breaks into their offices and steals things, they now have months of customers' credit card numbers at their disposal. So there's been a lot of arguing back and forth between vendors and the credit card companies over what is actually the right thing to do and what provides the customers with the most protection as opposed to what protects Visa and MasterCard. So for the people who actually need this, I just put together a quick little list. These are some web pages here. The slides will be posted online at some point through NOTACON. And these just have long lists of the various privacy legislations, both in the US and around the world. So for the people who need to know this for work-related stuff, these are some great resources. So meanwhile, as I was talking about before, the laws we're talking about were all state level, so it varies. The rules vary from state to state. Some things say things about encryption. Some things say things don't say anything about encryption. Some states require central reporting of this information. Some don't. So it's getting very complicated. It's pissing people off, both at our side as the people who are the recipients of these letters, as well as companies. large companies tend to deal in multiple states, and in fact, some of these laws are actually in direct contrast with each other, which means you have to choose, well, which states am I actually going to be compliant with this law? So there's been a lot of effort at the federal level to come up with one overarching law for the entire U.S. that would cover who, when do you send out breach notification letters? How do you send them out? What are the rules for that? But so far, they've all pretty much died in committee, either in the House of Representatives or the Senate. It's not, despite the sort of chattering of various Congress critters, it actually does not appear to be a high priority. So as a result, it never actually gets enough attention to make progress forward. This would be great if I need a nap. So in addition to the stuff about breaches, when I'm not really going to talk much more about that, there have been several other pieces of legislation dedicated to protecting your personal information, most notably GLBA, which is a banking legislation which mandates that the banks protect your personal financial information to a certain extent, and HIPAA, which is supposed to protect your healthcare information, but doesn't actually really do much aside from make auditors have more checklists to go through when they work with hospitals and doctors' offices and whatnot. Now, probably of more interest to this crowd is actually the Patriot Act, FISA, CAILIA, and mood legislation like that. Now, the Patriot Act, I'm assuming that everyone's heard of the Patriot Act in here. And the big thing about the Patriot Act is it allows for warrantless searches of anything, whether it's your computers, your paper records, your house, your place of business, with no actual right to protest it, to appeal it, or even to tell anyone else about it that it even happened under what they're calling national security letters. And it's been really hard to figure out what's been going on, but enough information has leaked out to show that the FBI, amongst others, has actually been seriously abusing this power and using it outside the scope of what they're supposed to. Under the letter of the law, it's only supposed to be used for investigating terrorism, but it's actually been shown to be used for all sorts of other things because there are no checks and balances for this. And speaking of sort of warrantless stuff, what's not on here is, it's not legislation, which is why it's not on the chart, but there's been obviously the NSA it's been doing its warrantless wiretapping stuff, which relates to FISA, in that they're claiming that the FISA court system is not sufficiently, isn't fast enough to actually provide them with wiretaps when they need them. Now, FISA was put in place after the Nixon administration to ensure that there were cases where there needed to be a warrant issued for a wiretap, where that warrant information couldn't be public information because it might put the investigation at risk. Now, the important thing about it is that you're supposed to go to the FISA court, get a warrant, do your wiretaps. But if for some reason you can't go to FISA because of time restrictions, you can start the wiretap and you have 48 to 72 hours, depending on the circumstances, to actually then go to the court and say, is it okay that we did this? And the court is supposed to be staffed, with enough people that, in fact, this can be done on a regular basis. So this whole warrantless wiretapping thing is kind of BS, to be polite about it. And related, because we're just full of warrant information on this bullet point here, is CAILIA. Now, CAILIA was a legislation put into effect in the late 80s, early 90s, I forget precisely when, but it mandates that all telecommunication providers must design their networks to allow the FBI or any law enforcement to wiretap from a central point in each central office to make it easier for them to do that. And you have to do it at the expense, the telecom providers have to do it at their own expense to do that architecture and that design. And I believe that is actually up for renewal in the next year or so. So if you're not too happy about that, I suggest you contact your Congress critters. A question?
Yes. Wasn't CAILIA be supposed to be only for broadband stuff? Not all network traffic?
So CAILIA was originally for... Sure. So CAILIA was actually for voice traffic and is still for voice traffic.
That's why they put it to broadband due to voice over IP.
Right, and now they're trying to actually alter CAILIA to account for voice over IP. It does, so the traditional voice over IP providers, so like AT&T, Sprint, and those folks actually have voice over IP options you can subscribe to, particularly if you're a big corporation. A lot of folks tend to route things over their their IP backbones. And in that case, you still need to provide CAILIA-like functionality for law enforcement. Now, the case of like Vonage or folks like that who provide pure voice over IP, they don't fall under CAILIA because they're not technically telecommunications providers under the law. So they're looking to extend CAILIA to include folks like Skype and Vonage and folks like that. And then there's a whole class, and there's dozens upon dozens of these companies out there right now who don't have to fall under that. Oh, by the way, so you have questions, feel free to ask them anywhere in the middle of the talk. You don't need to wait till the end.
Okay, I've got a question. We'll go back to HIPAA.
Yes.
And that's to keep our information, medical information, et cetera, private.
Correct.
Our hospital uses our social security number as an identification on all our medical records. How did they get away with it? They put it on the armband that they cut off and throw in the garbage can when you're discharged, and they put it on all of your records.
Yeah, they don't.
Sent to the insurance company and God knows what.
Yeah, so HIPAA is kind of a weird beast. It doesn't actually say anything about your social security number. It just says that you're supposed to follow best practices. Now, the fact of the matter is, there's a variety of legislation that says they shouldn't be using your social security number. So, in fact, I would bring that up with the hospital system. They should be issuing other unique identifiers that are not social security number based. But you'll notice as a result of HIPAA, your health insurance cards that you get in the mail no longer have your social security number on them, or if they do, it only has a portion of it because there's legislation that's in effect in most states now that say you can't use your social security number as on anything that's publicly viewable. So the idea of it not being on your health insurance card is that, well, someone could look over your shoulder if your wallet gets stolen. You don't want your social security number getting lost. But there's nothing that specifically says the hospital internally can't use that number. But in some states, if you request it, they actually have to use something else. But nothing stops them from using that as the default.
Well, they've been told about it, and they refuse to answer questions.
Talk to me afterwards. I might be able to help you out a little bit. Any other questions right now? I thought I stuck up other hands.
Just a comment. Regarding HIPAA, there's only really two sections of it that really apply to most companies. The first section is if you have a breach of medical information, it's up to a $10,000 fine per record. And the second half of it is you have to have X policies in place. So when an auditor comes in, they basically go through an audit checklist and say, you have this policy, is it enforced? It doesn't say that they have to protect your social security number. It just they have to have a policy that says it'll be protected. So when you send that HIPAA document, all you're doing is saying, I admit, I know you have policies regarding this. It really has no teeth to it at all.
It's just a number of people that get a hold of those papers. All the secretary, all the nurses.
Right. That's one of the problems.
Garbage can, they don't shred it.
Yeah, but that's one of the problems with HIPAA. And to be certified compliant with HIPAA, you just need to demonstrate that you have a process and policies that you follow consistently. If you tell your auditors, we consistently throw these in the trash every single time, they say, great, you have a process. You're following the process. It's like the old ISO 9600 certifications. As long as you say, here's what I'm going to do, here's how I do it, and here's the proof that I'm doing it, great, you're golden. It doesn't actually say anything about the quality of the process itself or how the quality of the end product coming out the door or how secure or how private you actually are. It just says that you've made a public statement of what you're doing and that you're following it consistently. Okay. So the other thing about HIPAA is that for the most part, it actually doesn't even have, there really aren't a lot of fines around this information. And in fact, recently, California passed, in addition to its breach notification laws that now put medical records and health insurance information under the same breach notification laws as your general personal information did as of 5 years ago. So if any hospital or insurance company or anyone else who handles that sort of information loses that data, they also have to send you a letter notifying you. And the general best practice has become that they also provide free credit monitoring, though that's not actually legally binding in any of the state laws right now. It's just sort of become the general practice of what companies are supposed to do to show that they're contrite. So I alluded to PCI earlier. So PCI, like I said, it was mandated by Visa and MasterCard as a process that the company is supposed to put in place to help protect credit card information. Really, it's about they say it's about identity theft. It's actually about fraud. It's an effort from the credit card companies to push down their effort to make sure that they're not losing very much money due to fraud. and they're pushing it down to the retailers to make their, so it's taking this effort off of Visa and MasterCard, and they can go to the retailers and say, if you haven't done this, we don't have to pay for fraud that comes out of your business, comes out of your pocket. So basically, this is sort of a high-level overview here. I'm not going to read all the bullets to you. You can do that yourself, of what retailers need to go through. And from a sort of enterprise perspective, this is all things that the larger companies are doing or should be doing today anyway. So where it really hurts a lot of companies are the smaller mom and pop businesses that aren't used to doing that. They have one cash register, maybe, and they have like the one cash register and the one zip strip, and they have 5 employees, and they have to follow more or less the same requirements as McDonald's and General Electric and eBay. And so it's there's been a lot of pushback from the smaller vendors on this legislation, saying that it's not being implemented fairly or evenly, and it's putting them at a great disadvantage in the general marketplace. And the main thing here in terms of privacy is that it's more defining than probably any of the other privacy legislation out there on what people should be doing. And so from that perspective, it's actually a good thing. It's really educating people on what the sort of, not really state of the art, but what, at what a base level people should be doing and thinking about. But it's a little too specific, so it makes it really hard for people to do things in what makes sense for their business rationality. So Canada. So that was, that's pretty much the U.S. there. Canada has both federal and territorial privacy laws here. I'm not going to go into too much detail, but feel free to hit me up afterwards. I have a bunch more information about that. But basically, there's the Privacy Act, which affects federal agencies and basically says what they can and can't do with your private information, and also says that if you contact the federal government in Canada, they actually have to tell you what information they have, what private information yours they have, and how they're using it, and you have the right to correct it. So if they have, wrong credit information for you, the wrong, whatever the equivalent of the Social Security number in Canada is, that sort of thing, you have the right to correct that and to find out what they have on you. It's not like the Freedom of Information Act, where you're going to get your dossier, but it is going to tell you the basic, information they have from you in terms of taxes and things like that. Then there's PIPEDA, or the Personal Information Protection and Electronic Documents Act, which is much more in the line of the U.S. Privacy Act, which combined with some of this breach notification type stuff, where it says, here's the list of things that companies may carry about you, what types of data they may collect, and how they may use it. Specifically, what they have, and we don't have in the U.S., is that if they collect personal data from you for a particular goal, like they say, we're collecting this information so we can do demographics on who's using our products so we can better focus it for marketing, they can't use it for anything else. They can only use it specifically for the lists of things they tell you that they're going to use it for, which is actually kind of cool. So you can actually make a better decision, as opposed to here in the U.S., where traditionally when you give them your personal information, you're signing away that they can use that data any way you want, unless you go the effort of filling out one of those little privacy forms that came from your financial provider or your healthcare provider saying, no, you can't share it with subsidiaries, partners, et cetera, et cetera, et cetera. And then usually there's ways around that anyway. And then this guy, David Fraser, he's a privacy lawyer in Canada. He has a really great blog about information about international privacy law and legislation, things like that. So if it's something you care about or have, want to track, he's the guy to follow, especially for stuff related to, obviously, to Canada, but he also follows most of Asia as well as chunks of Europe, since they tend to, a lot of the folks are following Canada's lead in that regard. So, for a while now, Europe had a piece of legislation in place called the European Data Directive, which was probably the first really big privacy law anywhere in the world, that said you can't export European citizens' data out of Europe without their explicit permission. And furthermore, even if they give you explicit permission, they can revoke that permission at any time, which is kind of cool, from a personal perspective. But from a business perspective, it gets kind of exciting at times, because it pretty much means that anyone who is if you run a US-based business and you have customers in Europe, at some point they can call you up and say, I want you to go through all your records and remove all my personal information, and you have to comply. So it can, from a business perspective, it can get pretty exciting, but from from a personal European citizen's perspective, it's really awesome. And in fact, Google is being currently investigated because the way they tend to share some of the information they collect from you back and forth through their data centers is a possible violation of the European Data Directive, given the way that the current terms of service are written through Google. So they're currently being investigated by the EU for violations into that. And pretty much this is going to be true for any major corporation that's doing business with end users. Google's just the most notable one because everyone's heard of them. In the UK now, it's a voluntary law called the UK Data Storage Law. They're very imaginative with their names over there sometimes. And basically, what it does is it tells ISPs they can volunteer to collect data about what emails are going back and forth, who it's from, who it's to, the size of the email, the date, the subject line. That's it. Nothing about the actual the internal contents of the email isn't being collected. And that's also supposed to be collected and stored for up to 3 years, not just for emails, but also for websites hit, for phone calls, things like that. Now, the rub is that it is voluntary, except for if you don't volunteer to do it, the UK government can step in and force you to do it. So they say it's voluntary, but it's not really voluntary if they don't want you to do. And then in Belgium, just this past fall, they passed a law that says you can't videotape people publicly. If you want to put security cameras out, you actually have to have a cute little icon indicating that there is a video camera there. And where it is, so you can't have hidden cameras in public streets. Like if you wander through New York or LA or parts of San Francisco, businesses have cameras all over the place, and if you look for them, you can see them hanging off buildings and whatnot. Well, in Belgium now, you can't do that unless you have the cute little picture of the camera on the wall pointing directly where the camera is. And you need to have a public commissioner whose job it is to interact with customers, so you can call up and say, I was walking by your bank, I want to know if you have footage of me or not. Now, you can't force them to delete it, but they at least have to go through and tell you whether it's there or not. And they're only allowed to store that for 30 days. And the only people who are allowed to view that tape are the security staff for security-related incidents that might happen. So they just can't be watching it. They actually have to have a reason to go back and look at it, or law enforcement under the equivalent of a warrant. Yes? Yeah.
Afterwards, that shows you taking part in a crime. Is that valid evidence if it was supposed to be destroyed anyway?
That's a good question. So the question was that if the data was actually held longer than 30 days and it shows evidence of a crime that you committed, whether that's admissible in court. I don't know. The law's only been in place for the last 6 months, so I don't know if to the best of my knowledge, it has not yet been tested in court. It does. The police do require a warrant to actually get access to that data and things like that. So it's definitely an interesting question.
Given I'm a European, I might add the comment, I'm pretty sure you can't use it in court.
Yeah, thank you.
I would say 99% for sure.
I would certainly hope that was the case. Okay, so Japan. This one I need my notes for. So Japan has this, the Personal Information Protection Law, which is somewhat based on Canada's law. They looked to Canada heavily when putting this law into practice. And what it does is, it actually just went into effect about a year ago, April 1st. And so what it says is that this applies to any company that has 5,000, that has private information on 5,000 people, and that includes both internal employees as well as outside customers. So, pretty much almost any decent-sized company in Japan falls under this. And it mandates that the company have a chief privacy officer of some sort on staff. And you have to state why you're collecting personal data, and you have to get consent for any future use beyond the reason it was stated for on the original forms where you requested the data. And so you also have to, like Canada and like a lot of Asia, there needs to be a process in place for correcting any errors in the data, which is, again, something we don't have in the US. Not that I'm bitter about that or anything. And if they fail to comply with the law, fines of up to $3,000 US and the equivalent of that, obviously, in Japanese currency, and 6 months in jail for the person actually responsible for managing that data. And that's probably the part that's actually the most compelling of this legislation in terms of people who have to follow it. I think $3,000 for most companies wouldn't make them blink, but 6 months in jail for the person responsible for the data is probably an attention getter, I think. So in Australia, they have a slew of different legislation. I'm not going to really get into that right now, but basically what we have is that there's different legislation that covers private businesses, the government, as well, and then there's a separate list for healthcare providers. So right now there's a huge effort going on to consolidate this legislation, trying to make it a little more uniform, because it's just, it's very confusing for everyone, not just the consumers, but the government officials aren't quite sure what they need to do. Healthcare providers, as I said, have their own little piece they need to do. And the various territories in Australia also all have their own legislation. So it makes the US stuff look really simple and clean compared to what's going on in Australia right now. So they're making some huge efforts, and there's a number of committees who have been providing comments, especially in the last year, over things that Australia can do to make things a little more uniform. But on the list of potential ideas, they were talking about extending do not call lists to include things like, right now they have the equivalent of a US do not call list, but it only applies to landlines, and they're looking to extending that to cell phones and fax machines, and also to email as well. But right now that's not in place. And additionally, there was one other thing that I wanted to mention. Oh, right now in Australia, if companies do less than $3 million a year in business, they're currently exempt from the legislation, and they're looking at lowering that number to a much smaller number, like $1 million or $750,000. As companies have been growing at a faster rate, they want to make sure that they're getting people in the right frame that way. There's been a lot of effort to produce the Asia-Pacific Economic Cooperative, which was sort of an international group similar to the EU, but much looser, to come up with privacy legislation for them that they could it's really a recommendation more than anything else. And recently, about 6 months ago, there was an academic in New Zealand. He went through and basically tore their framework to shreds, because every single one of the member states of the organization had much stricter privacy law than were being recommended by the consortium itself. Which I think says more about how the organization was run, that that everyone in there has stricter laws than they're recommending that other people follow. And also, several pieces of the framework are in direct conflict with European data legislation, which means that it would make, if anyone were to actually sign up and follow those rules by the letter of the framework, that it would be incredibly hard to do business between the UK and the rest of Europe and Australia. And considering that Australia in particular, but any of the Asia-Pac corporations, cooperatives, since several of them are Commonwealth countries of the UK, it would make things particularly exciting for them. Okay, so the real question is, in the business world, how do you make this work? How do you actually get your companies to be a little more privacy aware? How do you make privacy work and not kill the business in the process? It sounds complicated, and if you are actually in a position to actually do something, it's not nearly as bad as it sounds. It's really more just a question of doing a lot of legwork. I did this at my previous employer, and we thought, this will be easy. We have executive sign-off, and we have lots of people from all the business units who are interested in doing this, so we should be able to knock this sucker out in like 3 months. Piece of cake, no problem. Yeah, exactly. We quickly found out. Now, this company was very centralized. All the applications were being run by information technology. There was only 5 major applications. We thought, really, how hard can this be? It's not like some of our competitors who have 1,000 applications, 1,500 applications, in one case, 10,000 applications. We have a pretty good grasp of the idea where data is going. So we started going out interviewing sales and alliances and tech support and engineering. We suddenly discovered that we had data on our customers going all over the place. Particularly in the case of alliances and sales, we had lots of conferences that we ran or participated in. It turned out there were all sorts of contractual agreements with these organizations for sharing leads and for sharing attendee information. And in some cases, we discovered that was actually in violation of European or Canadian or Asia Pac law, so we actually had to go in and renegotiate contracts to bring ourselves within compliance. But really it came down to these 4 bullet points is, where do you do business? The most important question is which laws do you care about, or which laws do you really need to care about? And so the first question you need to find out is, where do you have offices? And more importantly, where are your customers, so you know which list of laws you need to worry about to begin with. And then it turns out also that some of this privacy law depends on where money is actually going. So in the UK, tax laws are different in Germany versus Ireland versus England versus France, and so some of the privacy law also affects that. So you need to know where's the money going, how's it being handled within the company, so you can make sure you're following the right financial laws as well as privacy laws. And then, of course, once you know where you're doing business and where the money going is, the question is, where's the data coming from and where's it going? This is where it got complicated even with our small little set of applications. And then the real success in doing this is most companies today already have major compliance efforts because of Sarbanes-Oxley and the aforementioned GLBA, HIPAA, things like that cost them significant money, even if it's just in sales, and not being able to say they're compliant. So leverage those efforts. A lot of this legwork is already being done to build policies and process, and it's not a lot of effort to add a little more on top of that to get your privacy stuff in line. And the other thing is you need to partner with legal, HR, all these folks who are really touching this data on a regular basis to make sure that their stuff is all in line. And fortunately, there's these folks, Unified Compliance, who have gone through and figured out all the major pieces of legislation in the US and around the world, and it's actually like 5 or 10 page Excel spreadsheet that you can download that shows all the typical controls companies use, cross-referenced with the appropriate legislation, so you can actually take this, go to your privacy officer or your compliance officer or your auditor or all 3, and say, as it's a great tool. It helped us out a lot. Was there a question in the back? Oh, okay. And use that to make sure you're not being redundant in your efforts, and this way you can make sure that privacy-related work that other people are probably already doing will get you where you need to go. Okay, future. Okay, so yes, so it turns out, here the U.S. has been actually fairly groundbreaking in terms of data breach notification. It's actually the first country to start notifying people explicitly that their data has been compromised and potentially exposed to malicious folks, whether it's internal people or outside people to the company. And to the point where now in the United Kingdom, a group of retailers has gotten together and is pushing for a similar law in the UK. And about 6-8 months ago, the government of the UK actually lost information on something like 25 million citizens. And even though there was nothing in place to mandate that they do that, there's been enough public pressure for this sort of thing to happen when companies or governments lose data that they actually publicly disclose that they had lost this information on all these people. Fortunately, about a month and a half ago, that data was actually found. The DVDs were actually located inside, underneath the keyboard of a lost laptop that someone got at a pawn shop. So they're fairly certain that data didn't really leak out there at all, but nonetheless, they did follow what is increasingly becoming a best practice on notifying people, even though there wasn't the legal stuff in place. I already talked about US vendors pushing back on the PCI compliance efforts, especially around the storage of this information. It's just really making things more difficult. Yes?
I was just wondering, do you know when they disclose what information has been lost on you? Do they follow like the solution, like your password got out or whatever? Here, why don't we change it? Or...
So the laws differ from state to state on when they need to notify you. Generally it's supposed to be within 30 to 60 days. However, anytime the police or the FBI are involved, they're allowed to tell the corporation to sit on it and to be quiet about it until the investigation is complete, or at a state where it will not impair the investigation if that information gets out. In a lot of cases, the information that was lost or stolen is still an ongoing effort by these hackers, in the pejorative sense, of course. So they don't want to actually, the criminals are in fact still performing this act, they want to have the time to track them down and actually catch them, as opposed to just getting them to stop. So sometimes the FBI or the police will ask you to hold off on notifying people until they can get to a point in the investigation where it's safe to, where it won't put that investigation at risk. And I mentioned earlier there was some privacy legislation going on in the government at the federal level, and the most notable one is the Leahy-Specter ID theft bill, which actually died in committee at the end of 2007 and is supposed to be revived this year, but so far I haven't seen anything about that yet. And that's pretty much it. Now is open for more questions, and hopefully I'll even have answers for you.
Yeah, I got a letter from the state of Ohio about 6 months ago. I think it was a stolen laptop or whatever. And I get a 1-year credit, or they secure my credit or whatever. They provided that. But I don't know what was stolen. What do I do after a year, or what should I do? It's just I got this letter, and here's this, and after that, good luck. I don't.
Okay, so basically the question was, the gentleman, presumably you used to work for the state of Ohio in some capacity, or still do?
No.
Okay, you were okay. So last year, about 6-9 months ago, the state of Ohio had a laptop be stolen. It was actually a contractor to the state. It was an intern who had information on something like 1 million former employees of the state, which would include anyone who worked for one of the Ohio State universities or anything like that. And it lost their names, addresses, phone numbers, social security numbers, which is actually probably what actually caused them to generate the letter, and in some cases some other personal information, possibly some credit history stuff, depending on if that was gathered in a background check before employment. Separately, also about the same time, Ohio State University lost a bunch of data on past applicants and students and staff and faculty. In both cases, letters were sent out to all the affected people, and in both cases also they worked with different companies to provide free credit monitoring. And what that's supposed to do is allow you to monitor your credit through the 3 major credit agencies, Experian, TransUnion, and whatever the other one is. So you can, basically, if anyone tries to open credit in your name, like say open up a new credit card or buy a house or buy a car on credit or something like that, it's supposed to generate a report to you, call you up, and say, is this really you? Right. They don't have to do this. It's sort of become, like I said, the best practice on what companies do to notify, to actually provide some credit monitoring. From what they've seen so far, generally, if some sort of fraud is going to happen as a result of that information being lost, it's going to be in the first year, which is sort of why people have been going for a year. I would certainly encourage you to continue going with some sort of service. I'm a subscriber to one. I can tell you afterwards which one it is. And anytime anyone tries to open credit in my name, whether it's because I'm, whether it's a new phone or a credit card or buying a car or something, I actually get called on my cell phone.
Is that the way this whole thing's going to wind up going for everybody?
Probably, yeah.
Is there a reason why those credit holds are only for 3 months?
There's a federal law that says that you are allowed to do it for up to 3 months. There's nothing that makes it further. Several of the credit protection companies out there will automatically renew that for you. So I use Debix, and every 3 months I get a letter in the mail telling me, thank you for we acknowledge that you put a hold on your credit for the next 3 months, and so that way I don't have to call them, write them a letter every 3 months. As part of my subscription, Debix automatically does that for me. There's a question in the back?
Yeah, in my company and in several other companies, of course, you have a unit in North America, one in Europe and China too, Is there anybody discussing making these more global, international treaty kind of things so that we have one set of rules?
There's been some discussion about it. I still think the privacy efforts, despite, realistically they've been going on for like 15, 20 years now at various levels, are still young enough in the process that the priorities here in the U.S. are very different than the ones in Asia and very different than the ones in Europe still. So I don't think that international level there's really going to be anything for quite a while. There have been some things put in place. So in the case of the European Data Directive, there's a couple of methodologies you can use that let you export data from the UK to Europe, from Europe and the UK to the US without invoking, personal authorization from each individual consumer at the other end. And there's a couple of different ways you can go about doing that. One's called Safe Harbor, where basically you get someone in a couple different organizations out there to certify that you are, technically compliant with, you have the process and technology in place to handle European data directive information at a comfort level equivalent to what companies inside Europe do. And then they say, okay, we acknowledge that, you, Oracle, or, you, General Electric, have good enough practices in place that will let you export the data from Europe to the US without getting consent from each individual consumer.
So the service that you said that you have for if somebody tries to use your credit information and such, whatever they call you up, isn't that like a complimentary service with a lot of credit cards?
It is complementary to credit cards, since the credit card agencies do their best to determine when fraud's going on and call you after the fact. But the credit card agencies aren't going to call you and say, "Did you really, try to have a new Visa card?" Or, if you or like you could call up, right? If you have my social security number, my mother's maiden name, and a couple other pieces of information, you could call up, AT&T and say, "I want a new cell phone, a new contract," and they'll happily give it to you using my personal information. And the credit card agencies aren't going to catch that. They're not looking for that. And certainly, the folks like Experian and TransUnion, the actual credit agencies, offer similar services. But considering that they haven't been protecting the information very well to begin with, I wouldn't really trust them. Why should we be paying them extra money to do something that they're already supposed to be doing and not doing a very good job of anyway? Any other questions?
Yeah, we see a lot of the phishing attacks and credit card attacks coming from Central America, South America, Russia, even China to some degree, and North Korea. What kind of things are going on there? I mean, you talked about the United States, Europe, the Pan-Asian area. But what kind of things are going on in those?
There's not a lot going on there right now, which is one of the reasons you're seeing that. Also, in general, there's the legal state of computer crime is very loose or non-existent in a lot of those countries, which is another reason that a lot of the stuff is originating out of there. In a lot of cases, the actual people doing it are somewhere else in the world, but they're launching the attacks from these countries because they don't have extradition agreements with the U.S., or it's not actually even illegal in those countries to be, doing those sorts of, what are crimes here, it's not illegal in there. So that's the real reason a lot of that stuff is coming from those places. Okay, well, thank you very much.
I wanted to make a comment. It's really amazing that the government lets so much of this information loose on us, yet on a lower level, when you go to a school district, they won't tell the teachers which student has a heart problem or which student has diabetes.
Yeah, all the presenters get copies.
What kind of format?
It's in DVD.
Okay.
Ooh.
Good.
Yeah, you can just leave that up there or leave it back there, I guess. I don't know what here's the other one.
Cool, thank you. Should we make another? Or is she gonna be?
These-
Well,